to start this recording. It's concerning case number 16 CR 4872. This is a unique case that went to trial on June 12th and 13th of 2018. The case is unique because the original three charges are as follows. Count 1, impersonating a peace officer. Count 2, possession of an illegal weapon, which is defined as possession of metallic knuckles and a few other items. Almost 2 years into the negotiations before the trial, an additional charge was added, a palpo, which is a unique charge in Colorado. It's possession of a weapon by a previous offender, which the brass knuckles can also qualify for if you're also a felon at the time that you possess them. This has a unique background in terms of who was involved and what exactly happened, but I want to get to the most important part of it first. We're going to jump forward to the trial phase, which involved a bifurcation. Bifurcation means that the trial would be held in two separate phases in front of the same jury. Colorado has a unique charge that requires that if it goes in the guilt and innocent phase, that it be separated because it uses the word previous offender. And a defendant on trial would be prejudiced by notifying the jury ahead of time that he has a previous offense. The problem in this scenario is that there's only a couple of things that you can never waive, and even in a plea agreement. And as a result, there's fundamental safeguards built into our judicial system and the computer systems that help coordinate the documentation of trials or the ongoing status of cases. That's called the ICON system, the Integrated Colorado Online Network. And what it is that it's basically the table of contents for any specific case number. That's going to be important later. And there's also a thing called a minimus. A minimus is a document that transfers jurisdiction from the judicial branch to the executive branch, which is where the defendant will end up in custody. It's a critical document. So, this criminal defendant goes to a trial, and the biggest problem that nobody realizes at the time of the trial is that count 2 and count 3 were to be sent to the jury in the bifurcated proceeding at the second phase. What happened was, due to an error in the trial, they separated the lesser included, which was the original illegal weapon, misdemeanor 1, and the palpo. So after the defense rest and the state rest, they send the jury with count 1 and 2. The jury comes back guilty on both. So now he has a conviction for the impersonating a peace officer which is an F6, and also a misdemeanor 1 for the brass knuckles. So now the court, not knowing that the guilty verdict on count 2 automatically killed the second part of the proceeding, but they don't realize that count 2 is a lesser included of count 3. As a result, they send the jury, they have a second proceeding in front of the same jury, and they send the jury to deliberate on count 3. That's a critical malfunction because as soon as the jury returned the earlier verdict on count 2, it voided count 3 immediately. This is critical because what's happened next is nobody, including the criminal defendant, the DA's office, nobody realizes that count 2 is a lesser included of count 3. So now the sentencing phase comes around. The defendant reappears in court and receives 18 months for count 1 and 2 and 30 months for count 3. He is now sentenced to the Department of Corrections for 48 months. It's the only thing that happens on the day of sentencing. So as a result, the next day, the court clerks and the judge reconvene to do administrative work, and the clerk brings to the judge's attention that the previous day's sentencing involved a double jeopardy issue, because when offense is a lesser included of the other, it is considered a double jeopardy because it's obviously the same offense. There's only one element that separates count 3 from count 2 in this case. Now, they conduct a 1-hour meeting concerning the fact that when the judicial assistant tried to enter into the minimus, which is a critical document, that because the double jeopardy issue is something that can never be waived, even in a plea agreement, can never be negotiated, because it's fundamentally being charged twice for the identical offense. And in this case, the trial involved one pair of brass knuckles, and the defendant was convicted of both the lesser and the greater. The clerk has now brought to the attention of Judge Thomas Kelly Kane that the minimus will not issue from the computer system because that's the one safeguard that is built into the system. It's rare and unusual, and it's a cornerstone of our judicial system. Regardless, in the course of this conversation, knowing after discussing it that because count 2 was sent to the jury first, that the 30-month component of this conviction is no longer any good. It was voided immediately. It could never be regained either. And remember, the court is in complete control of how the counts go to the jury. I know this is a little bit confusing, but follow me. This is very important. So on September 4th, and this is all on the documents that I forwarded to you, the defendant is the only one in the court, in a sentence to the 48 months. The following day, on the 5th, as documented also in the things that I forwarded, it's clear that they have a 1-hour meeting. The judge, knowing that the lion's share of the time of the 48 months, which would be 30 months, has to be removed. It's no good. It could never be any good because of the malfunction that happened earlier. As a result, the judge says, void all of the counts and issue the minimus. Just print the document. What's unique is that how we know that happened is because on September 6th, 2 days after the sentencing, there is a second date stamp on the minimus. Now, this is very critical because this is not a simple error of law that transpired in the course of the trial. This goes beyond that. This is where the actual officers of the court decided that they would issue a void document and send someone to the Department of Corrections instead of what their judicial duty is, and that is to correct the error. This is so significant because of a number of factors. First of all, bifurcations of a guilt and innocent phase of a trial is very rare to begin with. And the reason that is because in the course of deciding to bifurcate one phase, the guilt and innocent phase, you have to make sure that not one element of whatever happens in the second phase has already been presented to the jury in the first phase. It's a very tricky maneuver. This is why most states do not have charges like possession of a weapon by a previous offender, a standalone charge, because it requires this type of interaction by the court. The court doesn't want to do this because it automatically can create a number of factors, including this one, which has never happened in history. But regardless, the point is that everybody made a conscious decision to take out every single thing that was in place to protect a criminal defendant in the state of Colorado and ignore them and have a discussion about how they would deliberately take someone's freedom and intentionally void out every single conviction, because if one conviction's no good, they're all no good under one case number. And as a result, they basically created a fraudulent document. There's a lot of things that happen in our system, but nothing like this. This is a rare and unusual case because everybody knows that this particular situation is no good. The reason why they went forward with it is because, like in so many other cases, people don't realize what's going on or don't have an idea of what just happened. They banked on that. The problem was that this criminal defendant was a very unique individual, and immediately or shortly after he discovered it, began to do follow-up. Now, there's other unique components about this, and that is that the court, after it was brought to their attention, could never actually correct it, because they would have to admit that they had done something criminal to begin with. What's unique, though, is that there would be someone's job at stake, and that would be Casey Kane, who was represented the state of Colorado as a district attorney, who later resigned over this issue because of the deliberate act. What happened was that the criminal defendant made a collateral attack on the conviction, and Casey Kane, realizing what had happened, immediately summoned to have him brought in for the conviction to be corrected. But the judge, 4 days after issuing the writ, demanding his body be brought to the court and have the judicial error corrected, the judge says, I can't allow that to happen. We'll all be in trouble if this guy comes in the courtroom. What are we going to do? So the court proceeded to do everything they could to avoid it. They subsequently denied the writ that was already issued 4 days later. And these are close sequence of events where everybody's having these discussions. This is a very serious problem that the court is just hoping will go away, or this defendant will just hopefully disappear off the face of the earth. Now, there's a number of things that have happened since. This case is in the Colorado Court of Appeals at this time, and the Court of Appeals is even going to not quite know how to address this. This becomes a huge liability for the state, for the people involved, and is going to create a tremendous amount of backlash. So, the Colorado Court of Appeals case number is 20 CV 1278, and is in front of and was served on the Court of Appeals and the Attorney General a week ago. This case is very significant because there's never been a double-dated minimus. You can never allow that to happen. A minimus can only be issued once with one date stamp and then subsequently amended. The other thing is that they tried to disguise, as you can see from the document, the second date. Beyond that, the idea that they voided out the convictions in the Register of Action not only shows that the system is, that the taxpayers spend millions of dollars to protect the lives of people that are engaged in the judicial system, but also to avoid something like this happening. All of these things were circumvented, and intentionally circumvented. These aren't things that you can say you didn't realize what you were doing. You had to make conscious decisions to override systems that are built in to safeguard these exact anomalies, is what they are. These things are so rare that the safeguards are almost useless because they should never even come into play. These are fundamental errors. When you're dealing with a bifurcation of a guilt and innocent phase of a trial, you must be extremely careful to review the evidence. How can a judge allow two charges, count 2 and count 3, to go to the jury when it has the word weapon in each one of them? That's something that's of extreme concern. But let's get past that. Those are things that could be overlooked. The idea that it would be brought to their attention and that they would deny someone justice intentionally. These are decisions that have to be made through intentional acts. There's no way around it. You simply cannot justify how this sequence of events happens without everybody being in on it and just holding their breath that it would work out. It's just something that's so far of a stretch for even our judicial system that it has to be recognized as something with tremendous consequences. The public needs to be aware that these type of things are going on. If they're going to take that type of decision-making lightly and throw someone in prison knowing that it's wrong, knowing that their mistakes are going to cause someone to spend time in prison for no reason, and you know what? They get so many cases legitimately through plea deals. Only 2% of all cases actually go to a jury. That you just have to The judicial system has to accept the error happened, and it's basically the defendant is the beneficiary of a legal accident. That's what it boils down to. They were not willing to make that concession and deliberately put everything at stake, including the public's trust in the judicial system, along with their careers and any number of other things. At the end of the day, the case that is currently in the Colorado Court of Appeals, there is only one outcome. It can only be corrected by them. There is no other way. They will immediately have to fix it. There's no other answer to it. A double jeopardy cannot ever exist in our jurisprudence system. In fact, the cornerstone of how our jurisprudence system was designed was to avoid a double jeopardy issue. That's why it can never be negotiated. You could never agree to it. It could never be allowed, because that in England was the way that they would enslave people back in the early onset of how our system was later established. They would basically go in and take multiple bites at an apple, when today the one thing that the state has is one chance to get a conviction, and that's it. What they did was, when they sent that jury with count 1 and 2, to send them with count 3 is not only ensuring that they win, but it's also allowing a fundamental error that has to be addressed immediately.